Okay, we just finished talking about the rules of attachment. And remember, attachment deals with the secured party's rights as against the debtor to certain collateral. So upon default, then the secured party has the right of repossession. So that's a claim against the debtor's right to the collateral. Now we're going to talk about perfection. And perfection deals with a secured party's interest and it being good against other secured parties' claims to the same collateral of the same debtor. So that's what we mean when we say perfection. Perfection, once a security interest has attached. Okay, so first thing we notice here is that in order to have perfection, we first have to have attachment. So the secured party has to have its interest attached to the collateral. Then we go further. A secured creditor must perfect his interest, making it good against other creditors. And there's different ways that we can perfect a security interest. And I've listed them here. We can file, we can do a central filing, and I'll talk about that in a second. We can take possession of the collateral, which perfects it. There's a special way to do consumer goods, and then we'll talk about what happens when we have movable collateral and fixtures. Okay, so let's talk about perfection by filing because this is the most common way to achieve perfection. Usually, we file a document called a financing statement. And there's a form called the UCC-1 form that is a typical financing statement that a lot of creditors use. Anyway, we'll file this document usually in the Secretary of State's office in the state where the debtor is located. And when we do this as a secured party, we're putting this on public file to give public notice to anybody out there who may be wondering that this secured party has an interest in this debtor's personal property, so that the next creditor that comes along and wants to become a secured party and wants to use the debtor's collateral or debtor's property as collateral, then they can go to the central filing office, usually the Secretary of State's office, and look to see if the debtor has already given another creditor an interest, a security interest in those same goods or that same property. If so, that second creditor may want to rethink, because we'll get into priority rules in a second, and as you might have guessed, the first creditor to file as to the property usually has priority to that property. So anyway, that's what's going on. Let's take a look at the financing statement and what it contains. It usually has the names of the parties, the debtor and the creditor, or the secured party in this case, a description of the collateral, and it makes reference to the security agreement. It doesn't have to contain the whole security agreement, but make reference to it. Okay, one crucial piece of information that has to be on the financing statement is the name of the debtor. And you might think, well, that's an easy thing, right? And that is surely very straightforward. However, there are name problems that come up from time to time. If I am going to loan money to, maybe I'm a bank and maybe I want to loan money to a customer of mine, and let's say the customer I know is Bob Smith. Right? And Bob Smith has a business, and he sells, it could be anything, sells mobile homes. And so I want to loan money to Bob Smith, and I want to take as collateral his inventory of mobile homes that he has on his lot. Okay, so we go ahead and do the transaction, we do the security agreement, I get a financing statement on file with the Secretary of State, and I put in there Bob Smith as the debtor and all inventory now owned and hereafter acquired. Okay. Bob Smith then operates his business officially as, let's say, Happy Day Incorporated, right? A name completely different than his own personal name. But I filed the financing statement under his name, Smith. Okay, so then Bob Smith goes out to a second bank and wants to borrow more money. Second bank says, well, wait a minute, we want to take your inventory as collateral, but let's go check the central filing records to see if there's anybody else out there that might be ahead of us in priority. So they check the records, and they check under the proper name, Happy Day Incorporated, and they find nothing. They find, of course, no interest by me that's been out there recorded because I did mine under a different name, Bob Smith. So they go ahead and loan the money. Happy Day Incorporated and Bob Smith all default on obligations to all banks, and as we'll find out, and as I'll mention later on, the debtor usually, and in this chapter, defaults, unfortunately, because that's when we get to talk about all the rules. Sometimes debtors actually do fulfill their obligations under these agreements, but we like to talk about it when they don't. So I like to say Bob stopped making his payments, defaulted on all his obligations, he's broke, he's in Mexico, we can't find him, and there's no chance of ever recovering anything from Bob Smith. So that leaves the collateral. And I want to go repossess the inventory based on my security interest, and so does Second Bank. And Second Bank, we end up in court fighting about it, and Second Bank says, well, we did a search of the Secretary of State's records and the UCC filings, and we found nothing under the business's actual name, Happy Day Incorporated, right? If that is, in fact, the name of the business that was operating, and I got it wrong in my filing, and I put his personal name instead of the business name, which was actually, the recipient of the loan and the owner of the collateral and all that, then I'm going to lose out. And the rule is this. How do we know? Well, the rule says if a computer search under the debtor's correct name would reveal the financing statement, then the record is sufficient. If it wouldn't, then it's not. So if Second Bank did a search of the Secretary of State's records on her computer under Happy Day Inc., there's no way they would have found Bob Smith. And so my filing is ineffective. However, one more example of this really quickly. What if, let's change the facts a little bit. What if I want to loan money, take inventory as security, and I know the actual name is Happy Day Incorporated? Or at least that's the name he uses on all of his documents, Happy Day Incorporated, etc. And so I use that and I make my filing using Happy Day Incorporated as the debtor. It turns out, actually, on his articles of incorporation with the state, when he incorporated his business, the name isn't Happy Day Incorporated, it's Happy Day Limited Incorporated. That's the actual official name according to the articles of incorporation when he incorporated. And so that's the official name of his business. But I used Happy Day Incorporated. Then we have the same thing. We have a Second Bank that comes in and they file under Happy Day Limited Incorporated. And then we fight about who's has priority as to the inventory. Well, we're going to use the rule. The rule says if a computer search under the debtor's correct name, Happy Day Limited Incorporated, would reveal the financing statement, then it's sufficient. So if you did a search under Happy Day Limited Incorporated, you would find Happy Day Incorporated. It would come up in your search. And so Second Bank should have been alerted based on that. And so my initial filing would be good. Okay. What about with other types of perfection? With accounts or intangible things, filing is the only way to perfect. Right? So if I'm going to try to perfect an interest in accounts receivable of the debtor or an intangible thing like a copyright or a trademark or something like that, then the only way to perfect that is by filing. By the way, notice something else. The financing statement that's filed does not have to have the debtor's signature to be valid. Because, again, this is not something that's between the secured creditor and the debtor. This is between secured creditor and other secured creditors. So we don't really need the debtor's signature. This is something the secured party can do on their own. Okay, the place of filing, I've just gotten done talking about that. Usually it's in the state of the debtor's location, their principal residence. And, questions come up. What if a debtor has more than one residence? Well, I always say you can never go wrong by over-filing. If a debtor lives half the year in Illinois and half the year in Arizona, why not file in both? And then if it comes up that the principal residence is, for instance, in Arizona, well, you're covered there too, right? You can never go wrong by over-filing, but technically it's in the state of the debtor's principal residence. What if it's a corporation? Where does a corporation reside? Well, usually a corporation has its residence where it has its chief executive office, its main offices. It could also be in the state where it's incorporated, so you would check that. So it could have a number of residences in that sense. So again, you can never go wrong by overfiling. Central filing. Most collateral requires filing with the central office of the state, like the Secretary of State's office, and they all now maintain databases that are accessible by computer. Fixtures, however, are a little bit different. First of all, let me tell you what a fixture is or give you an example. Fixtures are personal property that are affixed permanently to land. And they're kind of quasi-personal property and quasi-land. And the UCC, Article 9, allows us to take security interests in fixtures, but they treat them a little bit differently. Let me give you an example of what a fixture would be. Maybe a radio tower. You know, a radio tower it's this big iron, or steel tower that has all kinds of electronic equipment. Well, when you erect a radio tower, it's not really designed to move from that spot. Usually it's set in concrete, it's got guy wires, it's meant to stay there. Well, the material used, the steel and all the radio equipment that's on the tower, that's personal property. And so what you have is personal property that's been affixed to land that's designed to stay there, a fixture. So the tower itself is a fixture. You can give a security interest in that. And when you do, you have to be careful of where to file your financing statement. Fixture filings, the creditor usually has a choice of central filing with the Secretary of State's office in the state where it's located, or a local filing. You can file it in the real estate records of the county where it sits, because again, it's affixed to real property or land, so you could actually go to the local land records and file. And as I always say, you can never go wrong by overfiling. Why not file them both? Okay, the duration of a filing. Once I file my financing statement, how long is that statement good? Well, the rule is financing statements are valid or effective for 5 years. A continuation statement may be filed, extending it for another 5 years. Okay, I don't know why, but the CPA exam loves this issue. They love to ask you how long a financing statement is valid, right? Well, it's 5 years. It's simple. And it can be continued for 5 years, and another 5 years, and another 5 years, on forever or until the obligation of the debtor has been satisfied. However, there's one little wrinkle here, and that is that the continuation statement that's filed, that continues the original filing, the continuation statement has to be filed within 6 months of the expiration of the original. So once you file your financing statement, wait 4.5 years, then you have 6 months before it expires to go ahead and file your continuation statement. That'll make it last another 5 years, and then you can file another continuation statement, and so on. Okay, let's talk about perfection by means other than filing. How about possession? Taking physical possession or possession of the property used as collateral. This is an alternative way of perfecting. And again, remember what we're talking about. Perfecting is making your interest good against other creditors. So how can you do that? You can take possession of it, right? Perfection by possession is good for goods, tangible personal property. You can take possession of them. Negotiable instruments, other instruments, promissory notes, things like that, if you take possession of them. Money, cash. The only way, in fact, to take security interest or perfect your security interest in cash is to take possession of it. You can't file a security statement saying, I have an interest in that guy's cash. You have to take it. Or tangible chattel paper, an actual consumer installment agreement that's in writing on paper. You can take possession of that. That'll give you perfection over other creditors' claim to it, or certain securities. And like I mentioned, the only way to perfect a security interest in cash has to be by possession. Maybe not possession, but control. You can also achieve perfection by control. And as I mentioned earlier, this is good for deposit accounts, right? Or a letter of credit, or what we call electronic chattel paper. And control is where the debtor gives exclusive rights or control over the property to the secured party, allowing them to withdraw if it's a deposit account, for instance. Mandatory control, in other words, the only way you can perfect certain collateral is through control, and that's deposit accounts, letters of credit have to be perfected by control. Okay, the secured creditor, if they take possession of the property, of the collateral, they have to use reasonable care in the custody and preservation of it. So if I take your property as collateral, and it's, again, let's use something that's somewhat fragile, an original painting, right? It's an original Rembrandt painting. It's very valuable. If I'm going to loan you money and I'm going to take the painting as security, and I'm going to do that by possession, I'm going to take possession of it, I have to take care not to ruin it while it's in my possession. And if I ruin it, you could sue me, right, as the debtor for ruining your obviously your personal property. So I can't do things like take your painting and just leave it outside in the weather. I would have to take reasonable care. Whatever a reasonable person would do to take care to preserve that collateral, I would have to do. But here's something it doesn't mean. if you're going to give me, for instance, stocks as collateral, I'm going to loan you money, and in exchange you're going to give me a certain amount of stock that you have in your company or maybe that you hold in another company. I have to, take reasonable care to preserve it, etc. But that does not extend to me as the secured party selling it at a high price. So if the value of the stock goes way up, I don't have any legal obligation to sell it just because the price is high. Likewise, if the price goes way down, I'm not responsible for a decrease in the value of it. That's not included in what we call the reasonable care custody of that type of collateral. Okay, consumer goods. Consumer goods are always a little different. Again, consumer goods are goods used primarily for household purposes. You probably recognize them when you see them. And now we're going to be introduced to a new term and a certain kind of security interest called a PMSI. PMSI is a purchase money security interest. Okay? Purchase money security interest is a security interest taken by the person advancing the money so that the debtor may use the loan, in this case, to purchase the collateral. That's purchase money. So when we talk about a purchase money loan, what I'm doing is, let's say that you come to me and want to borrow some money to go out and buy a piece of equipment. A purchase money loan is where I loan you the money, and the money I give you, you turn around and use to buy the equipment. And then you give me a security interest in the equipment you just bought. That's a PMSI, purchase money security interest. Right? You're giving me a security interest in the property that you bought with the money that I loaned you. Right? That's purchase money. Now, not all loans are purchase money loans. What if you already have equipment in your business? Let's use Bob's garage, right? Bob has some equipment, some tools and things, diagnostic machine, and he wants to use that as collateral to the bank. He wants to borrow money from the bank to make payroll. He says, I need to pay my other workers, mechanics and things, and I need some money to do that. And the bank says, well, what do you have as collateral? He says, well, I have this existing equipment, and I can give you an interest in that. Right? So the bank might loan him the money. Now, it doesn't go to buy the collateral. It goes to pay his employees. So that's not a purchase money loan, just so you understand the difference. If you have a PMSI in consumer goods, what's the big deal? Who cares? Well, that's why we have this slide, right? The big deal is a PMSI in consumer goods is perfected automatically without filing. Okay, think Best Buy. That's why I put the picture of Best Buy up there, because here's my example, right? Consumers go to Best Buy and they buy consumer goods all the time. They buy refrigerators. I guess Best Buy has refrigerators. They buy big screen TVs and those kinds of things, stereo equipment. And a lot of times the customers that come in don't have the cash to pay the whole price, right? So Best Buy, or the financing company that Best Buy works with, will loan the consumer money to buy the item, the big screen TV, and they'll take the big screen TV that the customer purchases as collateral for the repayment of the loan by the consumer, by the customer. So I go into Best Buy, I want to buy a television, it's $2,000. I say, I don't have $2,000. They say, that's all right, we'll loan you the money. You pay us back over time, and in exchange, if you don't pay us back, you agree to allow us to come repossess your TV, which is a consumer good. And I say, okay, and we do the security agreement. Okay. The big deal with that is it's a PMSI, it's a purchase money security interest that I'm giving to Best Buy. I use the money they extended to me on credit to buy the collateral that I'm now giving them an interest in. All right, the big deal with that is Best Buy doesn't have to go out and file a financing statement for the TV that they sold me. Why? Because it's a consumer good, and they extended a PMSI, or purchase money loan, and I've given them a PMSI in consumer goods. So their interest in my TV is perfected without filing, automatically. Why? Because it's consumer goods and they extended purchase money. All right, the reason we have this rule, and it makes sense if you think about it. Can you imagine if Best Buy had to go to the Secretary of State's office and file a UCC1 or a financing statement for every piece of consumer goods that they sold on credit? They couldn't keep up. The Secretary of State's office would be inundated with that. There'd be so many of those transactions. So we just don't require it. We just say, all right, for consumer goods, and you're a retail seller like Best Buy that extends credit, we're just going to let you automatically perfect your interest without a filing. Okay, what if the goods are movable? Or what if we move the goods around, or what if the debtor moves around? What do we do with our security interest? Well, here's some rules on that. When the debtor moves to a new state, then the security interest remains effective for 4 months automatically. So here's the scenario. Let's say I'm here in Illinois. I borrow money from a bank in Illinois. I'm a resident here. The bank then files a financing statement. I give them some collateral and my equipment and inventory and everything I have. They go ahead and file that financing statement with the Illinois Secretary of State. Okay. Then, before I satisfy my obligation, before I repay the entire loan, I pick up and move. And I move to Texas. Right? And I get it to Texas, and I go to a bank in Texas. And I establish residency there in Texas and everything for a little while. And I have a local address, and I go to the local bank in Texas, and I say, hey, I want to borrow some money. And then I want to use the same collateral for this second loan now that I used for the loan in Illinois. And I gave to the Illinois bank as security. And so the Texas bank says, okay, we'll loan you the money. Let us do a filing search, though, before we loan you the money. So they file the records in Texas. And, of course, they find nothing from the Illinois bank. And so based on that, they go ahead and loan me the money, and they take the security interest in the same collateral that I used the first time in Illinois. Okay, so I go broke. I'm in Mexico. I don't pay back either bank, and both banks come looking for the collateral to repossess it. What's the result there? Well, we have our rule. When the debtor moves to a new state, the security interest in that collateral remains perfected for 4 months. So that means the original security agreement or interest filed by the Illinois bank remains good for 4 months. After that, if it's longer than 4 months and they haven't filed in Texas, then there's lapses, and now the Texas bank would take priority. Okay, so this is these rules are a good reason why banks or secured parties really need to keep close tabs on their debtors and the collateral, and that's why they do that. By the way, if you've ever wondered, if you've gone to a bank and you've filled out a loan application and you wonder why they need to know your address for the last 5 years, this may be one reason, right? Some lawyer somewhere told the bank, hey, you need to go check the previous states where this guy has lived to see if there's any UCC filings there before you loan any money. So that may be one reason why they want to know that. Also, if the collateral moves, what if I just move the collateral to a new place? Well, here's the rule. When collateral is transferred to a new state, perfection remains for 1 year. So let's say I go to an Illinois bank and I use my painting, my original Rembrandt painting as collateral, and I don't give them possession of it, though. They just do a financing statement. They file it with the Illinois Secretary of State's office, and then I take the painting to Ohio, and I go to Ohio Bank and I say, I want to borrow money from you. Oh, and here's this Rembrandt painting, and I'll give it to you. You can take a security interest by possession. And I give them the painting. Okay. Then the question is, what about the financing statement from the bank in Illinois? Is that going to be good? Well, it says when the collateral is transferred to the new state, the perfection remains effective for 1 year. If it's the debtor that moves, it's only 4 months. But if it's the collateral, it's a year. All right. Really movable goods. Let's talk about what happens when the collateral itself is by its nature movable, right? Like vehicles and the like. So we have movable goods rules usually do not apply to things like vehicles, mobile homes, boats, even some tractors or bigger pieces of equipment, because there's a statute in those states that deal with perfection of security interest in those things, specifically outside of UCC Article 9. I like to put in this category any kind of movable goods that have a certificate of title, because that's really what we're talking about. So for vehicles, most of us can understand that. When you own a vehicle, of course, you have the certificate of title, right? Certificate of title indicates that you are the owner. State title laws usually require that the security interest, if the secured creditor is going to take a security interest in a vehicle, that be noted directly on that document, the certificate of title. And I don't know if you can see over here to the left, I think this is from Arizona. That's a sample of a certificate of title for a vehicle. And there's a spot right on the front of the certificate itself for the lien holder to put their name. so that if anybody comes into contact with that certificate of title, they'll know right away just by looking at it who holds the security interest. Right? So banks or any secured parties, they don't have to go to the Secretary of State's office and do a filing of a financing statement or all that. We just put it right on the ownership document, and everyone knows this. Same thing for mobile homes, for boats, and again, some tractors and those types of collateral. So how do we perfect? We place the secured party's name right on the title, or some banks will take possession of the title, and some will do both. If you've gotten a car loan, you know that maybe your bank that you borrowed the money through, they will keep the title, to keep possession of it until you make your last payment. Then they'll give it back to you, and they do that so they can make sure that they're perfected, their security interest is perfected in